When am I coming out of the video?
Good afternoon. Thank you very much for tuning in to our webinar dealing with the risk of fraud in private and public sector contracts. You'll hear from Marion Smith QC, who's a specialist in commercial and construction litigation and arbitration, and also in PFI contracts. From Rose Grogan, who's got a broad commercial, procurement, and public law practice. And from myself, I'm a junior specializing in commercial and public law. The way we propose to divide the speaking is that I will introduce the main guidance documents, primarily the two public procurement notices, and then more detailed model contract terms and FAQs. Marion and the nature of fraud risks in outline. That'll be followed by Marion looking more closely at the contractual terms that might be used both to recover payments that have been fraudulently or improperly obtained, and more general points to look out for. And then Rose will address specialist procurement and wider public law concerns that both public authorities, in particular local authorities, and their suppliers and contractors should look out for. Without further ado, I will make a start. The government's brief to public authorities is really to take a central part or play a central role in the wider response to COVID-19, and where local authorities and NHS bodies and others come in is in an economic capacity to support suppliers and contractors by accelerating payments and ensuring that they can continue to provide services even where they are facing pressures and are unable to perform as usual. And in the main policy documents, which I outline next, the general message to public authorities is to relax contractual milestones, be more flexible with timescales that are found in contracts, and not to strictly enforce KPIs and service level requirements. And there is even provision in PPN 02 for considering advance payments and other extraordinary measures in order to boost cash flow. And the overarching purpose of this seems to be not just to support suppliers and contractors, but the employees, subcontractors, and the wider supply chain that depends on them. And the next two slides outline the main sources of guidance. Rose will be speaking more fully about PPN 0120, which was the first guidance document, and essentially, as she will develop, it explains which usual provisions of procurement law continue to apply and in what way. I will speak a bit more fully, and Marion will deal in some detail with PPN 0220, which is probably the most relevant guidance document when it comes to payments and in turn the fraud risks that arise from those. There is also a shorter guidance document called Fraud Control in Emergency Management. That's really an overview document from the Cabinet Office, but it makes a couple of substantive points that I will develop in a moment. And then a few weeks on, after this initial round of guidance documents, the Cabinet Office has very helpfully provided what are model terms. And the first document, Model Interim Payment Terms, is a general model terms for suppliers, and then there are more bespoke construction contract model terms. And Marion will go through the drafting and potential risks and potential solutions on those. And then lastly, there's a more general FAQ document dealing specifically with PPN 0220, and that is constantly updated. And as you'll see, it came out on the 6th of April and it's been updated twice since, most recently on the 17th. An interesting question that arises is, what is the status of these documents? And the short answer is that they are simply guidance. They don't have the force of legislation. However, those familiar with the procurement sphere will know that PPNs are routinely used, and these PPNs are particularly clear as to what's expected as not just best practice, but standard practice at this time. And particularly PPN 0220 and the model terms provide quite a lot of detail by way of guidance. And tying it in with broader public law concerns, local authorities and other public authorities would do well to consider them very closely, as they are likely to be construed as relevant considerations and because of the wider duty to act consistently with published policy. And so where the decision is taken not to follow clear instructions where found in these guidance documents, the reasons for that should be clearly documented and should be spelt out as fully as possible to explain the departure. And that's because of a background risk of judicial review or other forms of challenge. Next, we turn to what is the heightened risk of fraud in the current climate. And this is taken from the shorter document that I had referred to, Emergency Control from the Cabinet Office. And essentially there are two major types of fraud risk. The first is first-party application fraud, where you are dealing with an existing underperforming supplier or contractor, and you already know them, but because of the resource and time constraints that are currently faced by most, if not all, public authorities in delivering services and keeping things running, the ability to vet them carefully and pick up on these failings in performance and pre-existing failings in performance may lead to certain suppliers who are really unmeritorious continuing to receive funds, and there may then be issues in recovering them from such suppliers or contractors. A related issue is third-party impersonation fraud. In that case, you are dealing not with an underperforming supplier, but with a third party that pretends to be an existing supplier. And that may happen because of the need to go beyond the existing pool and not being able to vet or have face-to-face interviews with potential suppliers before engaging them, particularly for emergency services. And I will, before I pass on to Marion, just go into two core features of PPN 0220. The first is the so-called open book approach. It is really quite extraordinary in the sense that it's a far-reaching requirement on suppliers and contractors to make available almost any underlying data or information that is requested by public authorities, insofar as it goes to how payments are processed or why there is a need for accelerated or altered payments. And the quote on the left-hand side of the slide is from PPN 02 itself. And then we find further specification in the general model interim payment terms, and Marion will explore that more fully, and then definitions as well in the two construction specific model terms, and so both NEC3 and JCT. And the other core feature of PPN 02 are very tangible accounting and auditing practices that public authorities can use in order to mitigate or at least minimize the effects and the risks of fraud. And the first point here is about personnel and building in a sort of connection between your policy team and the more operational teams, and having someone in your team who is looking out for these fraud risks and can begin to spot standard patterns or past patterns indeed. The next two are more typical auditing measures, so low friction countermeasures and post-event assurance checks. Just to explain the second, that's about looking at performance and perhaps asking suppliers or contractors to provide follow-up reports in case there's any doubt about the services they've delivered, particularly where there's a temporary change in service levels or the quality of a service. And the fourth point is really quite significant, and it's something that's borne out by PPN 0120 as well. And that's about not all procurement that takes place in the current climate is necessarily emergency procurement or indeed emergency payments. And it's important to think very carefully about which services are longer term and don't necessarily require a contractual variation or other change, and which are immediate needs which require a bespoke solution right now. And that's another very useful method of minimizing the overall impact and risk of fraud. And lastly, something that Rose will address in quite some detail is looking at how one can work with trusted suppliers in order to not be unduly or favorable or engage in favoritism, but in order to use that existing trust in order to have the best possible and almost a frictionless relationship at this time, or at least one based on trust. And she'll talk more fully about amending and also the issue of blacklisting, where certain suppliers aren't doing what they should. And now over to Marion. Thank you.
Thank you very much, Philip. And I hope that I can now turn up on the screen, although I can't see myself in the bottom right-hand corner. Dealing with the risk of fraud, looking at the contractual provisions. And I want to do that because I come from the school where fraud is the F word, and if at all possible, you look to present what is a fraud claim as being a claim for breach of contract. And the other thing I'm going to look at is set off and clawback, as those are the two main remedies that the current scheme envisages. Let's start, please, with page 11 of the slides, and let's just remind ourselves as to how this all started. Now, it was clear from the outset that the government was concerned to avoid misuse of what was going to be a flood of money. Collaboration is good, but it brings with it obligations. And you can see the main points set out in PPN 0220. And it's worth knowing what they are, because you will see as we look through the proposed model terms that they refer back to this general policy. Firstly, to work collaboratively to ensure transparency, a need to be able to demonstrate that payments have been used in the manner intended. Now, they give examples of that, again, not to limit, but to illustrate. Can you show that the staff have been paid the right amount and on time? Can you show as the supplier that cash flow has happened through the supply chain as quickly as possible? A theme of PPN 02, keeping records of decisions and agreements. Now, to my mind, that is like telling people, do not drink bleach. You wouldn't think you have to say it, but you do. And given the speed at which decisions will be taken, and given the seriousness of the allegations that you might ultimately have to make, the need for compelling evidence is clear, and that is only obtained through writing. Keep notes, send yourself emails, some form of quickly capturing what you've just said and done. The supplier must have no expectation of making profits on undelivered contractual elements. All suppliers to operate with integrity, not to operate honestly, not to commit criminal offences, but to operate with integrity. And then they must expect action to recover payments if the supplier takes undue advantage or fails to act transparently and with integrity. So you can see the concerns there were at the time. We're going to give you this money. Will you use it in the manner intended? Now, if we then turn on to the next slide, we will see that we've got model terms for construction contracts, which are the ones I'd like to look at first, because my impression is that these are more carefully thought through, and I think provide us all with some guidance as to what we might be able to do in the non-construction contract sphere. Can I start by saying, though, that if you are going to use the model terms for construction contracts, you must be very careful about their impact on existing bespoke amendments to the underlying construction contract. We all know the standard forms NEC3 and JCT, and we all know that everybody has their own bespoke amendments, which dramatically or potentially dramatically change the meaning of these contracts. And then if you superimpose on that a variation, the consequences have to be thought through very carefully. Both of them in the model terms start with a recital saying that there's an obligation in the variation, proposed variation model terms, to act in good faith and to work together towards the aims and principles set out in PPN 02. You see, that's the first cross-reference back to that general philosophy. Then if we move on now to the next slide, just to give you a sphere, a feeling of the structure, Z2 contains within it these 5 elements. Open book reporting, which Philip has talked about. It deals with payment during the COVID relief period. It deals with the recovery of payment. It deals with warranties, and it deals with payments. And recovery, to my mind, logically ought to have come at the end, because it refers back to the previous obligations, but it doesn't. It's there in the middle. Can I look at the next slide, please, slide 13? This is the one that you would have expected to be in there. It's an express obligation to ensure that the payments made by the employer as a COVID relief are promptly and solely applied to the purposes for which they are made. That was the driving philosophy that we could see underpinning PPN 02. If we look at the next slide, please, you'll see that the obligation has broadened out. It's to act transparently and with integrity and at all times in good faith and using best endeavours. And that express provision has been written into both the JCT model terms and into the NEC3 model terms. Now, if you want to look at that, you could say to yourself, what do I have to show breach? Just one of them or all of them? And what do they all add together? Because to act in good faith, doesn't that include acting transparently? Why do I need with integrity in addition? And then superimposing on that, using best endeavours, which, as we all know, is a phrase that causes its own problems in interpretation. Anyway, there it is. It's in as a general obligation in both. Now, if we go on to the next slide, we will see what has become one of the main concerns. This is what is stressed in the model terms, and it's the obligation not to combine. Now, the red lettering numbering that I've added. It's not in the text. It's just take our eye through it. If you'd like to come through this clause with me, and I'll take this one a little slowly, and then we'll see the pattern repeated with modifications in the other proposed model terms. Now, the contractor, point 1, not entitled to combine, and shall procure that the key persons shall not combine any COVID relief provided pursuant to this deed, so what we give you, with, little 2, any government COVID-19 related relief grant, intervention or other measure. So that's the start of it. You mustn't combine the two, which, point 3, results in receiving relief for more than once, notice that way of putting it, more than once for the same underlying cash flow issue, which in the reasonable opinion of the employer, notice that, reasonable, not a free-ranging discretion there, it's got to be a reasonable opinion. I'll come back to 6, take your eye on to 7, would amount to the contractor taking undue advantage. Now that's got quite a few elements in it, but it is breached when in the reasonable opinion of the employer, it amounts to taking undue advantage. 6 is in there to just show that we're all guilty of block copier errors. Shall I put it that way? I can't see that it should be there. To my mind, it's just simply something that didn't get picked up in the last typo check. I felt comforted that the Cabinet Office could do that. I apologise if in fact it is meant to be there. I also took comfort from the fact that the emphasis that is put in these model terms on not combining shows a growing awareness on the part of the government as to what the fraud risks were. This has become, to my mind, the main theme. I'd be interested in hearing through the chat box, which please feel free to enter any questions you have for us during this. If you've seen that that is one of the problems you have to address, preventing the combination. And what I would suggest is that you regularly review what you're learning. We've got quite a period now of the COVID lockdown and the COVID coming out of the lockdown period, in which you may continue to be operating this sort of philosophy. You need to review the problems that are occurring and to ask yourself, are my model terms on which I make this relief available fit for purpose? Do I now need to modify them to address new risks that are emerging? If we turn on to the next slide, we can see that this is the relief. If the contractor either fails to comply with the provisions of any of this clause 7.2, so if you can show, for example, a breach of the obligation on page 16, and oblique or a freestanding takes undue advantage of any COVID relief. And remember the clause we were just looking at, clause 7.2, the breach of that would fall under 7.2.3.1 and had within it an element of taking undue advantage. This one is a freestanding obligation not to take undue advantage. And notice it's in the employer's opinion, not his reasonable opinion, but in the employer's opinion. Now, to my mind, that is going to be read not as a complete discretion. You would have to show that you weren't acting as the employer vexatiously or in a similar way. But as we know, that's quite difficult to establish. And then the last one has failed to expend any COVID relief for the intended purpose or as agreed by the employer. And that, we can see, harks back to the underlying philosophy set out in PPN 2. So if you've got one of those events, the next slide will show you what you can do. If we could go on to page 18, the employer shall be entitled, and again, with my signposting through that clause, without limitation, so there's no suggestion that you're cutting down your common law rights. You might want to think though about writing that in expressly. You may, without limitation, 2, retain or set off the reconciled value. It's worth looking at the definition of the reconciled value. You will see that what that is basically the amount of the COVID relief that's provided. You can retain or set it off from any amount due and or outstanding under this deed or any other contract. So that's a wide-ranging set off and retention. Or you can recover the reconciled value as a debt due and payable, and you can deduct it from the prices, which is the contract price. Now, bear in mind that when that's put as a variation into an NEC3 contract or any construction contract, you've got some form of payment obligation against which you could seek to apply that debt. You may not have that as part of a general supply contract. There's no attempt in the model deed Z2.3 to actually put out a mechanism for crystallizing the debt or for speeding up recovery of the debt through the courts. Now, if we turn on then to the next slide, please. Same pattern in the JCT. I just want you to notice that what's happened here is that the expression at point 4 is slightly different from how it was put under the NEC3. Here, you have to receive relief twice for the same underlying cash flow issue, whereas under NEC3, it was not receiving relief more than once. Now, I don't know why they've used different wording. I hope that there's a rationale behind it. It seemed to me it may not make a difference, but it's something that you'd like to think about. If we turn on to the next clause, because I'd like to get into the supplier contracts, which we're in now. These are the interim payment terms, which have to have a different structure. What they've done, if you turn on to the next slide, can I just highlight a few points for you? What it's done in clause 2 is to set out the general propositions. 2 is important, an express acknowledgement mutual that it's given in accordance with the policy set out in PPN 2. So we're always, when we're looking at interpreting what this contract means down the line, with this clause in, we're going to look back at the principles in PPN02. If you think you're going to need to add or amend or supplement that, then you should be amending clause 2. Important point in point 4, the supplier acknowledges that any relief given is at the sole discretion of the authority. There will be an argument as to whether or not there are the limited fetters on that, not to act vexatiously, and other similar unacceptable conduct. But what it plainly isn't is any relief is given to it at the reasonable discretion of the authority in the sense of standard general negligence. I'm not talking about Wednesbury unreasonableness. If we then move on to the next slide, you'll see that's very similar to what you expect. That was what PPN 2 was talking about. You will apply the money promptly and solely for the purposes for which they're paid. If you move on to the next one, please, you can see in clause 6.6, spelling out what the supplier is not entitled to, and there at the last bullet point, not entitled to combine, but slightly differently again, which results in the supplier receiving more than one benefit or relief. Then if we go on, let's have a look at the obligations, the interim payment terms. Slightly different approach here again. If in the reasonable opinion of the authority, that's different from what we've seen before. You've then got 4 propositions, 4 breaches, fails to meet any obligation in the variation, fails to apply it to meet any proposal in the application, takes undue advantage, and fails to act transparently and with integrity. Now, what I think you should be thinking about doing here is asking yourself throughout the process, what do I now think constitutes undue advantage? What do I want someone to do so as to act transparently and with integrity? And consider drafting in specific examples of the conduct that you would expect. If you go on to part 2 of clause 7, you will see that this is the remedy provision, and it's limited. It contains the retaining or setting off. It's still all action necessary. It is arguably retaining or setting off not the entire payment, but to the extent that it is money that has been obtained or to which the obligations in 7.1 and 7.4 apply. There is no reference to recovering the money as a debt. And one of the things you might want to consider is actually expressly writing in a procedure for clawback, for giving of specific notice, that the notice either is conclusive evidence or must be challenged within a very limited period, and the right then to pursue through the courts quickly. Let me pass you over to Rose. Let me take any questions you've got about that when we come back. There are many, many issues on this drafting.
Good afternoon. So in this section of the webinar, I'm going to be talking about the public law issues that arise out of giving supplier relief and the fraud risks that Philippe and Marion have outlined. If we could go on to the next slide, please, Philippe. There are 3 broad areas that I'm going to touch on. First of all is amendments to existing contracts. Then I'm going to look at the issue of blacklisting and what happens to those who abuse the COVID relief that we've been talking about. And finally, just looking at other public law issues that might arise when renegotiating and modifying existing contracts to respond to the pandemic. So first of all, we have amendments to existing contracts. I mention this because obviously what the government is envisaging is that instead of relying on termination force majeure, what public sector bodies will be expected to do is to try and reach flexible arrangements with their suppliers to get them through this part of the crisis. Now, where your contract has been procured, so where it's subject to the public contracts regulations, the government position is that the PCRs continue to apply. So you'll need to pay careful attention to the provisions that allow for modifying contracts in Regulation 72 of the PCR because they are limited to specified circumstances that I'll come on to in a second. Now, when we're thinking about where modifying contracts may come in, we've got a broad list of issues that may arise. We have obviously extensions to terms of existing contracts that might have been expiring within the last few months, introduction of additional goods or services to public contracts. Settlement of disputes is also caught by Regulation 72 if you're doing something that modifies an existing contract. It also applies not just to expanding the scope of your contract, but reducing the scope of the services or the goods that you were looking for. And when we're thinking about COVID relief, we're also thinking about forbearance from existing contractual entitlements. So modifying a contract can arise where a public sector body decides not to enforce its strict legal rights, where it decides to let things slide and not to take advantage of its contractual rights. And also, obviously, issues around modifications to price or payment provisions, especially in circumstances where they advantage a contractor and may result in breaches of equal treatment or transparency. So when you're in the territory of looking at modifying an existing contract, you need to pay close attention to Regulation 72. What I'm going to do now is just go through a number of different safe havens that arise from Regulation 72. I'm not going to go through the entire list, but just want to highlight a number of provisions that might apply in these circumstances to the response to the pandemic and to supplier relief. So if we go on to the next slide, the first one is Reg 72(1)A. So that's where the modifications have been provided for in the initial procurement document. So where you have a review clause that A, states the scope and nature of possible modifications or options, as well as the conditions under which they may be used, and B, do not provide for modifications or options that would alter the overall nature of the contract or the framework agreement. So an example of a clear and precise modification review clause would be, for example, the extension of time provisions that you get in construction contracts that Marian's just been talking about. It tells you what the risk or delay events are, it tells you when they might arise, and it tells you what happens. It's important to note that general variation clauses, so broad variation clauses that just say any variations to be agreed in writing or something along those lines, are not sufficient to satisfy the requirements of Regulation 72(1)A. So if you're in the business of looking into your existing contract to provide relief for a supplier or to maintain or expand a relationship with a trusted supplier as part of your fraud mitigation plan, you need to make sure, if you're using Regulation 72(1)A, that you do have that clear and precise review clause there. Otherwise, it's not going to be of much help to you. Moving on then to the next slide. This provides for additional work, services or supplies that have become necessary and were not included in the additional procurement, where a change of contractor cannot be made for economic or technical reasons, so both of them have to be satisfied, would cause significant inconvenience or substantial duplication of costs. Certainly when you're looking at depleted workforces, this may well be a useful safe haven to rely on, where you need to secure additional work, services or supplies from an existing contractor, and where you can do so whilst also mitigating the risk of having to go back out to the market and deal with suppliers who you don't know, who have not been vetted. Note there, obviously, that there's a provision that any increase in price cannot exceed 50% of the value of the original contract. Moving on to the next slide, please. 72(1)C is the provision that the government guidance of PPN 0120 focuses on. It says this is the one that you are probably most likely to use. And there are three conditions there. One, the need for modification has been brought about by circumstances which a diligent contracting authority could not have foreseen. And the government has been quite clear that this pandemic is circumstances that could not have been reasonably foreseen. Two, the modification does not alter the overall nature of the contract. And three, any increase in price does not exceed 50% of the value of the original contract or framework. Now, I've not been able to find anywhere where 72(1)(c has been tested by the English courts. I suspect we will get litigation coming through the pipeline eventually that seeks to test the boundaries of this, and certainly what altering the overall nature of a contract might in fact mean. But at the moment we have no guidance to really help us on what that might mean. Moving on then to the next slide. You're also obviously entitled to modify where the modifications are not substantial within the meaning of paragraph 8 of Reg 72. The definition of substantial, which I've just summarized here, and I've not included everything. Substantial amendment would obviously where the agreement becomes materially different. Had the modification been part of the original procurement, it would have allowed for admission of other candidates. Modification changes the economic balance in favor of the contractor or extends the scope considerably. The third bullet point there on my list, modification changes the economic balance in favor of the contractor, I think is a particular risk area here, because where you're granting supplier relief, so where you are getting creative around issues of price or how payment is made, you may well be shifting risk from the local authority, sorry, from the contractor to the your local authority or contracting authority, where they're starting to assume more of a risk than they had before. An example of this, again, in construction contracts is that your delay risk for a pandemic sits with the contractor unless you've amended it under bespoke terms in the JCT contract. And so if there's any supplier relief or creative amendments to contracts going on around that, that may well take you out of Regulation 72(8), and you'd have to look for a different safe haven or risk running a new procurement process, which obviously defeats the purpose of the supplier relief and trying to maintain existing agreements that the government is so keen on. Moving on then to the next topic, just a reminder there before I do of the different remedies you may have for breach of Reg 72. You've got the declaration of ineffectiveness, damages, and also potential judicial review and set aside of decisions. So moving on now to my next topic, exclusion from future procurement. This deals with what happens when a public authority thinks that there's been bad behaviour on the part of a supplier or a contractor during the coronavirus crisis and wants to seek to exclude them from future procurement processes. The FAQs on PPN 0220 warn that fraudulent claims under COVID-19 support funds may lead to exclusion from future procurement competitions. And the example it gives there is where you're furloughing staff, for example, but those staff are actually continuing to work for you and you're claiming then additional COVID relief from your contracting partner to maintain those workers in work. The entitlement to exclude comes from Regulation 57(8)(c) of the public contract regulations, which gives you a discretion to exclude bidders from participating in a procurement process. That applies where the contracting authority can demonstrate, the burden is on the contracting authority, that the bidder is guilty of grave professional misconduct, which renders its integrity questionable. Now, before I go on to look at what that actually means in practice, it is important to note that there are, of course, the mandatory exclusion grounds where you've got a conviction for proper fraud with a capital P and a capital F, so bribery, corruption offences, where there's mandatory exclusion applies. But here, this is the discretionary exclusion, and the test there is grave professional misconduct. So moving on to the next slide, what does that mean? So professional misconduct is not limited to the standards of the profession to which the bidder belongs. So if you are procuring some form of professional services, you don't just need to look at what that professional body would define as misconduct. It can include other wrongful conduct broadly construed. Again, there's not much in the way of case law on this. The one case I could find is an Italian case, Consorzio Nazionale Servizi Società Cooperativa versus Gruppo Torinese Trasporti. And that was a case where breach of competition law was considered to be capable of amounting to professional misconduct. I've only been able to access a summary of the case because it's only in Italian, and as you can probably tell, my Italian ain't great. But what the summary says is that the court was keen to emphasize that the fact of a breach is not enough. So what you can't say as a contracting authority is you have been found to be in breach of competition law, for example, and that means you are automatically entitled to exercise your discretion to exclude. You have to look at the conduct and consider it individually and consider whether or not it would amount to wrongful conduct. So in the case here that the government gives of double claiming under COVID relief, as a public authority, what you have to assure yourself is that you've got reasonable grounds to demonstrate that they have in fact done it. I think that's going to be very difficult in practice. I think you're more likely to be in the territory of having a strong suspicion that a company has behaved badly, but I'm not convinced that this warning of exclusion from the future has that much in the way of teeth. But it probably is something that's likely to be tested when we start working through the consequences of all of this. There's also a query outstanding as to what stage you can exclude a bidder. That was floated in the Ryhurst case, which came out very recently, where it was alleged that a procurement had been abandoned because the preferred bidder was connected to the Grenfell Tower tragedy. It wasn't dealt with in the judgment, but it was mentioned that it's not clear whether or not you have to exercise your discretion to exclude at the beginning stages, so at your PQQ stage, or whether or not you can exclude at a later stage as well. So that's another issue that's likely probably to be tested in the future, but to which we don't currently have an answer. So moving on now to the final topic, other public law risks. It's important to bear in mind that as especially local authorities and central government departments, as a public body, you are still amenable to judicial review when you exercise contractual rights or when you seek to negotiate commercial agreements. So although you are working in the private law sphere, as a public body, you are still amenable to judicial review. Now, the case law on this is a very long and complicated history. And the most recent word on it comes from the Privy Council in the case of Mauritius and CT Power that helps to make things a little bit simpler. And it was held there that public law applies to the negotiation of commercial agreements by a public body, but the public body has a very wide margin of discretion, and a successful challenge to the exercise of that discretion is likely to require evidence of fraud, corruption, or bad faith. It was also held that it's not an abusive process to bring judicial review proceedings and a civil claim for damages in respect of the same decision. So you can see a world there where you might have a third party disappointed bidder, for example, who both judicially reviews a decision to modify a contract and also claims breach of Regulation 72 of the PCR. And that would be a case that would get twin tracked here in the TCC, but you would have the two claims. How does this apply in terms of supplier relief and fraud risk? I think what we're less concerned with here is capital C corruption on the part of a local authority or bad faith, and more the accidents and mishaps that can arise out of working from home. So people are being given more delegated decision powers than they otherwise would be. People are off operating on their own. As Marion said, things are happening very quickly and records aren't being kept. And so you may well end up in a situation where a contractor is granted relief and that decision is challenged, and what looks like bad faith and what is the thing that drags you through the courts is more likely to be some kind of error, but maybe doesn't get you to the point of actually a successful judicial review. But obviously, through the course of that drama, you will have expended time and resources on a judicial review claim that could have been avoided. So it's important to be aware that even though it looks like the case law is quite friendly on this to public sector bodies, the risk of a judicial review is still there, and all of the time, money and resources that might get expended on defending a judicial review are important considerations, especially when everyone is already so stretched. And so it's important, as Marion said, to ensure good record keeping, the rationale for decisions is documented, and that where, for example, you are in the business of applying the PCRs, that you do make sure that you document your decision making by making reference to the legal tests, so that if you do get challenged, you have a clear paper trail of what you've done and why. And that brings me to the end of my section. And I think now we have time for some questions and answers, if anybody has them. We've got the chat function on the bottom, the Q&A bar that you should be able to see. If you can just type a question in there. We won't attribute questions to any participants. We'll just read them out and then we'll try to answer them if we've got time.
Yeah, and hopefully we can lose the Q&A session from the screen.
Yes. Okay.
I think if you take your screen share off.
Great.
Thank you. Marion, the first question that has come through for you is on the status of the Cabinet Office guidance document. So where parties have adopted the model terms in some form at least, what is the status of the PPM and the guidance notes that accompany the model terms when it comes to construing those contracts?
Well, the model terms envisage that you will directly incorporate them and that you will adopt those as the policy and the approach that you will take. So that takes them out of general factual matrix, which I think they would always have been a part of, something known to the parties, or reasonably to have been known to the parties, and it's put them centre stage. They are one of the documents that you will use to interpret and construe what is meant by integrity. So important. And as I said during my session, if you think there's anything else that you want to illustrate what you mean by lack of integrity or bad faith or not using best endeavours, think about capturing it and getting signed agreement. You may be very grateful when a dispute breaks out.
Thank you. We've had another question for Rose, and at the start of your presentation, you touched on the concept of transparency. What exactly does that entail for suppliers and local authorities respectively? From a procurement angle, what is meant by transparency?
There are two transparency obligations in play. You have the transparency obligations that come out of EU law that attach to contracting authorities, and they come to us through the procurement regulations. And that applies in your sort of running of a procurement process, and then also modifying procured contracts. That doesn't really translate to what you expect a supplier to do. So there's no EU obligation of transparency on a supplier. So who knows, frankly, what transparency means in the context of these model terms, other than we have the reference to the open book process. And in my experience in dealing with contracts that have open book review provisions in them, that is effectively a keys to the warehouse type situation where your local authority, your public sector body, the contracting party is entitled to see your accounting records. But there's no real obligation on the provider to make those accounting records easily readable or understandable. So when you end up in litigation and you've got an open book review related dispute, you can end up spending a lot of time and resources piecing together the other side's accounting information and what's actually happened. And it can be very difficult and time consuming.
Thank you. And I think then at the moment, one more question, and I think this is for Marion. You spent quite a lot of time going through the construction model terms, and this question is about the general supply terms. And if you had to identify one or two particular risks that you think, or issues that might arise from the drafting of the general model terms, what would they be?
The general model terms, I think the main thing for me is consider some form of crystallization of debt, so that you are required to serve a notice, it's conclusive evidence, you can then, within a very short period of time, go straight to your county court if it's at the appropriate level, the High Court if it's not. Because I think what's going to be really important is to have the time and the staff to monitor. There's no point having all of these rights if you then put the contract in the cupboard and never check that there has been compliance. You need to monitor, and then you need to run. Don't they say that a good credit controller has their running shoes in the office? You will need them. Because what will happen is that someone who is facing an allegation of lack of integrity or similar is not, never say never, but is unlikely to hang around. And we are going to face a high level of liquidation and bankruptcies in any event, let alone with these allegations being bandied around. So that's my main tip. And the other one, I think that the model supply terms are less clear. I think they're both vague. I understand why they are, but I think you might think, really would stress, think about ways in which you can identify the conduct you want. Demonstrate, illustrate examples. You will never identify everything you need, but you can identify some of it. I hope that's helpful.
Thank you, Marion. I'm just checking whether we have any further questions. I think that might be it for now. It leaves to me to thank everyone involved, our marketing team as well, and IT team, and Marion and Rose. And we will be putting up the slides in due course, and also making available a recording for anyone who wants to rewatch at least parts of the session, or to pass them on to others. Thank you very much for tuning in.
Thank you very much.
Thank you.
Thank you. Thank you, Philip.